All rise. Court of Appeals in and for the 5th District of the State of Florida is now in session. The Honorable William D. Palmer, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. In God save the United States of America and the State of Florida and this honorable court. Please be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. As you've already heard, I'm Judge Palmer. To my right is Judge Lawson. To my left is Judge Cohen. There are just two cases on the docket today. They're both civil cases, so each side will have 20 minutes. The appellant can reserve as much time for rebuttal as they choose. The first case being heard is KARR versus VITRY.
May it please the court. My name is William Johnson. I represent a lady by the name of Susan E. KARR. Ms. KARR was appointed as the plenary guardian of the person and property of her aunt, Natalie Evelyn Pearson. That was in September 29th, 2010. Prior to filing the guardianship, Ms. KARR testified that she had assisted her aunt as far back as 1997. For over a decade with her financial affairs and personal affairs. The ward passed away on March 27, 2012, and today's appeal is in regard to the lower court's ruling. There are two orders that were both generated by a hearing that we had on the guardian's final report, the final accounting, the guardian's petition for discharge, and the petition for guardian's compensation. That occurred October 10th, 2000.
With respect to the bank accounts?
Yes.
It was uncontroverted that the two Florida bank accounts were jointly titled, correct?
Correct, Judge. And on the lower court's ruling, the judge actually held that the guardian's name had, well, prior to her being guardian, had been added to those accounts.
And it's the titling at the time of death that would be significant, correct?
Correct, Judge.
Okay, and then with respect to the, I believe it was Kentucky account, what was the evidence of joint titling?
Well, there was testimony by the guardian as to the accounts being jointly titled. She testified repeatedly, in fact, correcting the lower court judge on occasion. I tried to admit
She testified that they were jointly owned, which isn't quite the same as jointly titled. Did she also testify that they were jointly titled?
I believe she testified they were jointly owned, which I think was her lay description of the account titling.
All the documents that were received into evidence would indicate that the account was not jointly titled, the Kentucky account at the time of the ward's death, correct?
I don't believe we had introduced any of the documents into evidence. That was point 4 of the appeal, that we attempted to admit the signature cards for those accounts.
Well, there are bank records that are part of the record on appeal that show the balance in the Kentucky account and show only the ward's name, and then there's another document that shows the ward care of the guardian.
I believe that she testified in that, I think it's on page 45, line 17, that was a pay on death account, was her understanding.
But it's your position that no documentary evidence, one way or the other, was introduced into evidence, correct?
Correct.
Okay.
Were the signature cards, which were not admitted into evidence, related to the Kentucky account?
Yes, one of them was, Judge.
And they were proffered?
Yes.
And what did they...
That was the first one we proffered.
Okay.
It was the out-of-state bank account.
And what did they reflect?
They reflected that she had signed as a joint tenant on the signature card.
And you argue in your briefs that they were properly authenticated by your client on the stand, which I agree with. The objection was hearsay, and I failed to see how you met the requirements or laid a foundation for the admission of the document over a hearsay objection. There was no records custodian from the bank who testified that it was a business record of the bank.
Correct, Judge. What we attempted to do at the lower court trial was, it was not in dispute that these accounts belonged to Ms. Pearson. What I was trying to establish is that Ms. KARR had signed the signature cards, and we presented the signature cards. Ms. KARR identified those as the ones that were sent to her from her aunt. She identified her signature on that, and she also said she had mailed those cards to the bank in question.
But that's an out-of-court statement, her signature, that you're trying to offer in court for the proof of the matter asserted, that this is her signature.
Well, she testified to her signature, first-person knowledge of her own signature.
Right, but that, what about the other signature? You needed the whole thing.
Well, it was not in dispute that the accounts belonged to Ms. Pearson. So that what I was just simply trying to establish that was Ms. KARR's signature had been added to that account.
The relevancy of it would have been the ownership, the title, how is this account, what form is the ownership of the account? And that would be hearsay, would it not?
It would, Judge. I agree to that. I'm just trying to establish that her putting her signature on that and mailing it to the bank, and then the judge, I believe, could have weighed what he thought as to the weight of evidence on that.
But that testimony came in, so so that testimony alone would be evidence of that the account was jointly titled, correct?
Correct.
Did she testify as to when she mailed it to the bank?
I do not recall, Judge. I believe the accounts, she testified that this was all done between 1997 and 2004. Prior to that, she testified that her mother's name had been on all these accounts. And she also testified that during that period, nobody else had helped her aunt.
Right.
Okay. So with regards to the bank accounts, it's our contention that the lower court misapplied the law with regard to that.
Just one more thing, in terms of the significance, the Kentucky account had a large balance at the time of the ward's death. That money was later transferred to the Florida accounts, but we're talking about the date, the ward's death. So this issue of whether it was jointly titled on the date of the ward's death is what matters with regard to the sum of money that was in that account at the time, correct?
And all these accounts were titled well before we even started the guardianship, and which would be well before the ward's death, obviously. We contend that the lower court misapplied the law with regard to the bank accounts, and in doing so, we refer to Florida statute 655.79 that creates the presumption of inheritance. If you read the lower court's ruling, they say that the names were added to, Ms. KARR's name was added to the accounts, but then they said that there was no evidence of a donative intent or a testamentary intent, and that, quite frankly, isn't the law. The statute creates...
Until the statute was amended, correct?
Correct.
You outlined that well in your brief, I understand.
Okay, so that created the presumption, and then the only three things that can overcome the presumption are fraud, duress, fraud, undue influence, or a contrary intent, and there was no evidence presented of a contrary intent. I refer back to that page 45, line 17, where Ms. KARR was asked directly what she believed the ward's intent was, and that was for her to inherit those accounts.
Wasn't there evidence presented that this was done for convenience?
Well, that's a different issue than the testamentary issue. Obviously, she was writing checks on her account for some time and helping her pay her bills. But the actual issue we're looking at, or I believe, is whether or not she intended her niece to inherit the accounts. And the appellee raised that issue as to whether or not it was a convenience account. And, there's a statute that controls convenience accounts, and one of the first criteria, the first line in that statute is that, the account has to be in one individual's name. you add them as signors, not a jointly or account with more than one name. And that's where the two statutes differ. The one statute controls if you have more than one person. The other statute controls if you have at least a single person with somebody with signer authority. So I believe that the testamentary capacity of the joint account was that it would pass to the niece. And there was no evidence presented, I believe, as to a contrary donative intent by the appellee. There's also the issue that we raised on appeal about the guardian compensation. As the court knows, 744.109 provides that a guardian may be compensated for their services. At the hearing, the judge asked my client if she had wanted to be compensated, and she said initially she was going to do the guardianship altruistically, for free, but when she waded into this and put in the hours that she put in, she decided to file a petition for reimbursement. The hours were actually presented in the form of a timesheet to the judge, where she went back and she admitted she had to go back and recreate this from her logs that she had at home. She's a consultant, and she had kept track on a different calendar.
Wouldn't you concede that many of those entries were insufficient in that they reflected time that a family member would normally spend, and some of them just were so lacking in detail that they wouldn't be sufficient to warrant the full payment that your client sought, even if she was entitled to a fee?
Well, I think the trial court erred in ordering no payment. I think that was an error. When you wade into something that you start altruistically and then find out it's going to take up most of your time, certainly you are free to change your mind, and it was never a condition of her being appointed that she not receive any compensation on the order appointing her the letters of guardianship. There was testimony by Ms. Carr's husband, as well as her assistant at the consulting firm, as to exactly what the nature and scope of a lot of those services were, and there was inquiry made as to what she did at the time that certainly could have filled in a lot of those blanks. We obviously, at that short hearing, didn't go through that petition line by line. Could she have done a better job? Probably. Did she try to do the best job she could? I would assume so. So yes, there could have been shortcomings in it, but certainly she was in a position to explain that away. She also mentioned that she stopped at a certain dollar figure just simply because there was that note that was out there, and that she actually invested more time than is reflected on the petition. However, she didn't see any need to keep going if there were no more assets in the estate or the guardianship.
As a matter of evidence, that doesn't help. If you put in for $80,000 and $40,000 is not justified for one, either because there's not enough detail or because it was the kind of thing that a family member would do for a relative in general, you can't get further than that just by saying, oh, well, I did more, right? I
would agree with that, Judge. You still have to provide the evidence of the hours, and I think there's a lot of cases that show you have to show the time and rate and what you exactly did. That is why on the appeal we asked that it be remanded to the lower court for a determination. I think the lower court erred by just simply not awarding anything, saying she wasn't entitled to anything, and I don't think that's what the statute calls for, and I did not find any case law.
Is it your position that if we reversed on that issue, there should be a new evidentiary hearing, or the trial judge should decide based on what was already presented?
I think there should be a new evidentiary hearing.
And is there authority to support that position?
I did not find any, no, Judge. The third issue I raised on appeal was the mobile home. My client testified that sometime prior to the guardianship, when her aunt first moved to Florida, which I believe was about 8 years ago, her aunt had sent her money to purchase a property for her. and that she had gone and purchased this mobile home, and at the closing, they had suggested, I think, or she, told them to put both the names on it as joint title with right of survivorship. Her aunt moved to Florida, and her aunt was fully aware that this property had been titled in joint tenants with right of survivorship. And I think my client testified that on occasion. She suggested...
It wasn't titled that way. I thought the testimony was that they went to do it but couldn't for some reason.
No, they couldn't go back to change it. She had suggested if you wanted to go correct the mobile home title, that we go back and do that, and her aunt never seemed to want
Change it to what?
Just into the aunt's name solely, if the aunt wanted to do that. For whatever reason, it was never changed, and, the aunt certainly was aware of that, and I guess our argument would be, though, that should pass just by virtue of the title on the mobile home. And then the last issue, and I think we addressed that already, was the issue of the signature cards and whether or not the client could admit those into evidence. I'd like to reserve 5 minutes for rebuttal.
What you have left is 5 minutes.
Thank you, Judge.
May it please the court?
How was the mobile home titled?
It's my understanding that the mobile home was titled in the name of the appellant only, that the decedent never did have the opportunity or never did go to have her name placed on the title. With respect to these issues, the first three all resulted in rulings by the lower court that were supported by competent substantial evidence. The trial court, or the trial judge, was able to the testimony, evaluate the credibility of the witnesses, and weigh the evidence. And
All the evidence with respect to the Florida accounts were that those accounts were jointly titled, correct?
no. The only evidence, and that is what is key here with this specific issue, the only evidence that was presented with respect to the accounts being jointly titled was the testimony of Ms. KARR saying that they were jointly titled. At the end of the day, that is the way it ended up from an evidentiary perspective.
The documents that are in our record on appeal were not presented at the evidentiary hearing, were not introduced into evidence?
The only thing that was on record, there was nothing introduced into evidence except for the testimony. Now, there were some documents, including the guardianship inventory, that reflected Ms. KARR's representation earlier on in the guardianship, that the accounts were owned 100% by the decedent. There may have been some computer-generated statements printed out that had both of their names on the accounts at some point in time, but there wasn't...
Those are part of the record on appeal, but your position is that they weren't evidence in the hearing, so they couldn't be considered on that issue.
Correct. Now,
The only evidence was her testimony. Now, why isn't her testimony substantial and competent evidence?
her testimony is not, in and of itself, is not sufficient. We're talking here about...
What authority do you have for that?
Well, we're talking here about triggering a presumption under Chapter 655.
Right, and the presumption requires that the accounts be jointly titled.
And the evidence, and the Merkel case speaks to this specifically. The evidence that needs to be presented is a contract with the bank or a signature card that indicates that the titles are in fact titled jointly. In Florida, there are two different types of joint accounts. You have tenancy by the entireties.
Merkel predated the statutory change, and I mean, the real holding was you needed survivorship language in those documents, which is no longer true, correct?
However, correct, but the key here is that the presumption was never triggered here. So you look at the other cases to figure out, whether or not...
The statute doesn't have any particular evidentiary requirement, correct? It just, the presumption attaches when it's established that the joint...
That it's a joint account, but again, the only evidence that we have in this situation is...
Is there an objection to her testimony?
To her testimony that she...
As to how the accounts were titled?
There was an objection with respect to the characterization of it being a joint account with right of survivorship.
But she said that they were,
But
correct?
that was her self-serving testimony, and that was all that there was there to substantiate
But I mean,
her representation.
A witness's testimony is evidence that's admissible and competent to support any finding of fact, right?
Correct, but there are other factors which the trial judge in this situation did consider, and that would be, if you look at the Beal Bank case, the 4 unities of joint ownership. He went through specifically and analyzed whether or not those unities were present.
That's irrelevant to the issue of whether the account was jointly titled. I mean, because that triggers a presumption. And the only evidence I see as to that issue, I mean, there was evidence as to how the ward intended that account to be used during her lifetime, but the only evidence as to joint titling, according to you, it seems like, is the guardian's testimony.
She testified that it was a joint account. That was presented, but she also testified, and it was a direct admission on her part, that those accounts, she did not consider those accounts to be hers. She did not contribute to any of the funds in the account.
What does that have to do with the testamentary intent of the ward?
Well, there's no, aside from her testimony, which is conflicting in that respect. First of all, if we back away from it for a second, and we look at it from a lifetime, the titling during lifetime, and then the testamentary aspect of it, there was nothing admitted into evidence other than her testimony to say, yes, these are joint accounts, with right of survivorship.
And you haven't shown me why that's not sufficient for the presumption that exists in the statute.
My position is that the 4 unities of ownership are not present.
That's not what the statute says. I mean, you have joint ownership, you have a presumption. And so the question is, what evidence is there as to the issue of joint ownership?
Her testimony is not the best evidence in this situation. There was a clear opportunity to present signature cards.
Was there a best evidence rule objection to her testimony?
There was an objection to when there was a proffer made for the admission of documents, bank documents, to prove how the accounts were titled. There was an objection to that.
And when they tried to give the best evidence, you had it, I mean, you objected on hearsay grounds, but I mean, you didn't object to her testimony, did you?
Not specifically on the grounds of best evidence. Now, the accounts, if you look at it purely from analyzing, there is, if you look at accounts, most times, there's been a lot of litigation in the state of Florida with regard to joint accounts versus convenience accounts. And if you look at it, basically, this is where the whole, the factors of Beal Bank come into play. Because a lot of banks don't automatically give people the form that says, do you want this to be a convenience account? Most people go in and say, I want to put this person on the account, especially in these guardianship scenarios or when people are becoming coming to a place in their life where they need people to assist them. They just say, I want this person to be on my account so they can help me. So you have to look at the Beal Bank case, look at the 4 unities of ownership to determine whether or not these are, in fact, joint accounts. Here, she specifically admitted she didn't contribute any of the funds, she didn't consider it hers.
That's not consistent with the statutory language, is it? I mean, the statute says, as Appellate's counsel pointed out, that the convenience account provided for in the statute is a single owner with other people who have a right to issue checks or make withdrawals on the account. And then there's a different category of account, which is jointly owned accounts.
There are different, and an interesting point here is that there are different types of joint accounts. You can have a joint account, or you can have a joint account with right of survivorship. Yes, she testified as a joint account, but then her testimony also supported it as a convenience account. If it was a joint account without right of survivorship, it would have been a tenants in common account, where she would have been entitled to just her interest at the time of death.
Signature cards had gotten into evidence. Would the presumption have arisen? Would she have won, except for the exclusion of the card?
The presumption would have been triggered, and it would have been a much higher burden for my client.
Of the signature cards would have been sufficient to create the presumption even without the names being on a
That
bank
is
statement,
correct.
et cetera. And the critical issue becomes the intent of the ward, is that correct?
In which situation?
In determining whether or not it's a joint account?
Correct, to overcome the presumption of it being a joint account, once that presumption is there.
The signature card was signed by both parties, sent to the bank, and it never got to the bank, or it wasn't in the bank records. Now you couldn't bring in the custodian of records from the bank to say, here's the card, because it's not there for some reason. Could the guardian in that case present the signature card and say, I can identify my signature, here's the state it was in when it came to me, I sent it on to the bank, my intent in sending it on to the bank was to go forward with the efforts to make it a joint account. Would that have been allowed?
I think that presents a whole host of other issues as to why the issue wasn't addressed during lifetime, that it never would have been converted to a joint account, and they would have had to have known it during their lifetime, so it would have presented a whole host of other issues. And in addition to that, in our situation, the person who added Ms. KARR to the account, she's no longer here to testify to her intent. So basically, we're looking at a situation where you need either bank documents, a contract with the bank, or the signature cards to establish that it was a right of survivorship account. Because if you don't,
If I sign a contract, can I introduce that contract into evidence if the contract's been provided to a third party, or do I have to bring in the record custodian of the third party to identify the contract?
Well, with this situation, when we're talking about a bank record, we're looking at, it was hearsay. When at the end of the day, when you...
My hypothetical, if I sign a contract and send it to you, you're the custodian of it, I keep a copy of it, but I don't have the original, can I introduce that contract by identifying my signature, or do I have to bring you in as the record custodian to identify the contract?
I haven't done the specific research on it, but I believe that you could probably testify to the fact that that is your signature. That does authenticate the document. Now, is there any other issue with respect to hearsay?
Is that contract hearsay?
I would have to look at the specific situation. I know that here it is.
Why is that different than the signature card in this case?
Because it's a bank document.
It's a bank document.
It's a bank document that was accepted by the bank. The decedent is not here to testify to her intent. And looking at, even though we have a statute in place that talks about when a presumption is triggered with respect to joint tenants with right of survivorship, you still have to, I don't think it invalidates prior reasoning in prior cases with respect to joint accounts overall. One of the very important things that I have to keep coming back to is that even though she testified that it was a joint account, we're back to a situation where it could simply have been, if she did not establish by the evidence that it was with rights of survivorship, then we're looking at a basic joint account, and then the question is, okay, what percentage of the account did you own? Nothing. She owned nothing. She admitted that. She didn't utilize the funds for herself.
There was no question about the fact that the ward did not intend to give this money away during her lifetime to anybody. She intended to keep it, but I also see no testimony other than that she intended it to go to the guardian upon her death.
If she wanted the money, it was testified that Ms. KARR herself testified that she was put on the account to help her aunt pay her bills. If the aunt...
intended that the money go to her upon her death, and they were jointly titled, and that she had a right of survivorship. She testified to all of that. How can you accept part of her testimony but ignore, relating to what she intended during her lifetime, but completely ignore the testimony that seems relevant to this issue, which is what she intended upon her death?
If she owned any portion of that account, if it was a joint account, period, or a joint account with right of survivorship, then she should not have reported it on the guardianship inventory as being 100% owned by the decedent and being 100%. Well, specifically, if it was a joint account, again, we don't have evidence of the right of survivorship. Based on just her oral testimony alone that it's a joint account, she should have delineated in the guardianship inventory what percentage she owned. We're not talking about a tenancy by the entirety titling. We're talking about a basic joint account.
Why is that inconsistent? This person owns this money, 100% it's hers, but it's jointly titled, and her intent is it go to somebody on death. Why are those things inconsistent?
The only evidence presented is her testimony.
Right.
That's not sufficient. Her testimony alone is not sufficient, because she did not present, when you have a situation when a person dies, and you want to establish who the beneficiaries are.
Testimony is sufficient to to convince a jury beyond a reasonable doubt as to a fact in a criminal case, I have a hard time understanding why, with a lesser burden, a single witness's testimony is insufficient to establish the facts necessary to support a presumption in a civil case.
If we're talking about a testamentary intent for the money to go to Ms. KARR, then it's our position, it's analogous to an estate. When you're trying to determine who the beneficiaries are, you either need a written will, or you need bank documents proving right of survivorship, or you need bank documents proving a pay-on-death designation. You need something in evidence other than someone's oral testimony that this was a joint account with right of survivorship.
With respect to a will, the statute creates all the requirements that you need, the witnesses, the notary, and all that kind of thing. I mean, but with respect to this statute and a jointly titled bank account, I don't see any of those evidentiary requirements in the statute. You just say it's your position, but...
I think that the statute was enacted to basically eliminate, if you look at the line of cases, there was a lot of confusion and a lot of litigation over these types of cases, so the statute was enacted to eliminate some of that. It didn't completely do away with the requirements of establishing a donative intent. And also, with respect to the statute, if you want the presumption to arise, you're going to have to admit some sort of evidence other than self-serving evidence that basically establishes how the account is titled.
The statute requires the four unities at this point?
I think that if the presumption isn't triggered, then I think you have to go back to Beal Bank and look at the four unities.
Presumption is triggered.
If the presumption is triggered by virtue of a contract or signature cards, then the presumption would be triggered, and you would have the burden as the other party to rebut that presumption with a clear and convincing evidence of the intent.
And you presented no contrary evidence on the presumption. I mean, you didn't
That's
come up with
correct.
bank records to show that, no, the testimony's not true, here are the actual records, it wasn't jointly titled, and you didn't present any contrary evidence.
That is correct, because the presumption was not triggered.
And assuming that the presumption was triggered, you would agree that there's not sufficient evidence to overcome the presumption.
I would not necessarily agree to that, because I would still argue that the accounts were treated during the decedent's lifetime as strictly convenience accounts. And again, if she's going to look at this as a situation where she gets the money at death, then she needs to establish the evidence to establish the donative intent. It's two different issues.
Well, but you're mixing, her intent during her lifetime
Correct.
with her intent upon death.
Well, I see them as two different issues. If we are looking at the statute itself in chapter 655, we're dealing with a joint account with the right of survivorship during a lifetime. So you don't even get to the issue of who gets these funds upon the death of one of the joint owners. You don't even get there. If you have a situation where you have an account and it's a convenience account, it's being treated like a convenience account, it's admittedly a convenience account for all intents and purposes. If you have not...
I agree that it doesn't meet the statutory definition of a convenience account if you accept her testimony that they were jointly titled.
I do not agree with that, actually, and that is a great point, because although you can have a jointly titled account and it can still be deemed a convenience account, and her testimony squarely supports the finding that it was a convenience account. She didn't contribute funds. She didn't utilize the funds for her purpose. She considered the money to be all of her aunt's. She was only put on the account to help her aunt pay bills. It follows squarely the line of reasoning to lead to a ruling that it's a convenience account. Then it's up to her to submit the proper evidence to establish that the funds should go to her upon death, because it's not a traditional joint account with the right of survivorship.
But you recognize that the statute says that a convenience account, it defines it as account with a single owner with other people who are added with the right to withdraw, but not jointly titled.
It does, but there are also cases, and this is where the litigation has arisen, and there's been a lot of litigation over these things in recent years, but just because the proper bank form wasn't used doesn't preclude a court from finding that it was in fact a convenience account.
In this case, the only potential heirs are cousins, correct?
Nieces and nephews of the decedent. Now, the decedent
Was the only one who was had any kind of relationship with?
she was the one that was in closest proximity. But
She's the one who cared for her.
she is the one that cared for her, but she was the one that was in the closest proximity. I mean, that's basically what it boiled down to.
Because she moved to Florida to take care of her.
Well, she also borrowed $80,000 from her aunt 4 months before she was deemed incapacitated, so it gets into all these factual issues, but at the end of the day, I think it still comes down to this joint account issue, and, not automatically assuming that because she says it's joint, it's with right of survivorship. I think you have to, back off of that and say, okay, well, there was no evidence admitted to establish the right of survivorship, therefore that presumption is not triggered, and therefore you have to analyze the Beal Bank unities and the factors under the case law that goes through the convenience account considerations, which is what I believe the trial court judge did.
Now, you say unless it was titled as joint with right of survivorship, 655.79 says if an account is in the names of 2 or more persons, it is presumed to have the effect of survivorship rights, correct?
I think that that's if you establish it.
Wasn't the statute amended to do away with this requirement that courts impose that there be survivorship language in the bank documents in order to trigger the presumption?
I think that even if let's go to that end of the spectrum and assume that the presumption was triggered, I think that there was enough admissions on Ms. KARR's part to go back and overcome that presumption to show that it was in fact a convenience account, and that it wasn't a right of survivorship account. So either way you look at it, it's Ms. KARR's, and she did say, yes, it was a joint account, but she also clearly admitted on multiple occasions all the factors you need to establish it was a convenience account. That overcomes the presumption with clear and convincing evidence, in my opinion, because it's her own admission.
Is it your position that she's entitled to no attorney's fees?
I'm sorry?
Is it not attorney's fees, but no fees for no guardianship fees?
It's my position that she did not do what was required under the statute, so unless, and I think that she had her opportunity.
She gets 0.
Only because she didn't present the logs in the detailed way that she should have. She could have.
So you agree that the trial court was wrong in its conclusion that because she originally decided she was going to do this for free, that she couldn't come in and get fees?
I think that the court was looking at her intent and kind of weighed her credibility, looking at the amounts in between.
The law says the guardian gets fees unless there's an agreement to the contrary, and there was no evidence of an agreement to the contrary, correct?
Provided they submit the necessary documentation to support the time spent, which she did not do. She had an opportunity to present those logs, and she didn't. So either way.
The judge never got to the issue of whether the documentation was in whole or in part. I agree with you that it's mostly insufficient, but it seems like there were some entries and some explanations that were sufficient as to some things. The trial judge never got there, right? Because the trial judge said, she didn't get fees at all.
I believe that he made a comment that they were vague.
That legal conclusion that she's not entitled to fees because she initially decided she would not ask for fees was incorrect.
I would agree that she would be entitled to fees at the judge's discretion, provided that the documentation was sufficient to support her claims.
How is
And
it
they were
at the
not.
judge's discretion if the documentation was sufficient? If she's entitled, the statute says she's entitled to fees, period.
Right. If the documentation was sufficient for certain entries, then sure, but for the most part, it was
The
not.
judge never reached that issue.
In the specifics that he reached, other issues, you're correct.
Your time has expired.
Okay, thank you.
May it please the court. I would like to correct myself earlier. The mobile home was in Ms. KARR's name only, and that they had attempted to go down and make it joint tenants with right of survivorship, and that trip never occurred.
And the evidence related to that was that at the time it was purchased, that, probably convenience is the wrong word given the argument on the other issue, but it was intended that the ward would be the equitable owner of the property. There's no question that it wasn't bought
Correct.
yet.
Correct.
And so I don't understand why you wouldn't have to establish the 4 indices of ownership with respect to the mobile home in order to prove her ownership interest in the mobile home. I mean, they could have titled it and transferred the ownership so that it was joint, but they didn't. So absent that, I just don't see how you get to her owning it without establishing those 4 requirements, and I don't see that proof.
The only argument I would have to that, Judge, is it just remained in her name and that change was never made.
Right.
With regard to the bank accounts, there's a case right on point, the Combi case by the Supreme Court. It talks about the new statute and why that statute was to eliminate all the mumbo-jumbo that was occurring with these analyses of bank accounts and how you don't have to...
We like mumbo jumbo.
Well, that gets me here. We're analyzing bank accounts under a contract law theory, not a tenancy or a will theory. And the Combi case goes on and talks about, cites the statute that says, notwithstanding the absence of proof of any donative intent or delivery, possession, dominion, control, or acceptance on the part of any person, and notwithstanding that the provisions hereof may constitute or cause a vesting or disposition of property or rights or interests therein, testamentary in nature, which except for the provision of this section would or might otherwise be void or voidable. So they're talking about that is the presumption attaching, and then this is the second half of that second paragraph about how you can overcome the presumption with the showing of fraud, under influence, or clear and convincing evidence of a separate intent. The Merkel case, as you may realize, went back to the earlier statute where they were talking about having to prove joint tenancy and the 4 elements of that. And in fact, this court in the Caputo case cites the Combi case, though it reaches a different conclusion because there was a contrary donative intent in that case, and that presumption was overcome. Nothing further. Thank you.
Thank you, counsel.